everybody. We are so glad to be back on Facebook Live. It's been a while since we've been able to resume Zoom. And I'm Susan Majors with IEP for Parents, and I am so thrilled to be joined by my partners in crime here tonight, Stephanie Langer.
Hi, everyone.
And Sue Meminger. So, ladies, tell us, why did we decide on October 21st that we had to resume Zoom? What was our big occasion that we wanted to talk about?
So today, which I did not remember, so thank you both to Sue and Susan, is our 1-year anniversary of our ruling in favor of one of our students, one of our clients in Sarasota. The DJ case, I'm sure you all heard us talk about it, but it's been a full year. I can't believe it. In some respects, it feels like 100 years ago to me. And in some respects, it feels like just yesterday. So it's very exciting to have be back and thinking about the case again and talking to you guys.
So what we want to tell everybody is, what does it really mean to win a due process? What does it really mean?
Because parents always win, right, Steph?
No, parents very rarely win. And the way that we won in this case was unique because we got a 109-page order, which was very detailed, and the judge was very thoughtful about how she wrote the ruling. I think she knew it would be potentially appealed by the district, so she wrote it in a way that we believe it will withstand appeal. It is also unique because of the relief that was awarded to the student in this case. And the relief included fees, which is always, when you're successful, you get reimbursed for attorney's fees. They also awarded as compensatory ed, 6.5 years of compensatory ed, which is very unprecedented, but very exciting. And they also awarded as a damage reimbursement to the advocates for the work that they did, which was integral to getting us to due process and getting us through due process and getting us to our successful outcome. So it's very exciting. What we win is the right to of free and appropriate public education, and this potential relief was comp ed. So you cannot recover for things like pain and suffering. If you missed 1,000 hours of work as a parent, you can't, the trauma that you personally have had to go through, none of those damages are recoverable in a special ed case. So it's very disappointing that parents lose time, energy, money that is never recoverable. So it's you have to be cautious when you file due process, because beside it being very hard to win, it's a classic David and Goliath kind of situation. The school board has all the records and all the witnesses and all the experts, and the parent doesn't have any of those things. But once you do win,
and taxpayer funding.
Taxpayer funded, endless pockets, endless time. That's their job. So they're not like having to quit work to do to litigate. It is very much a litigation posture. The school districts hire not only their own attorneys, they'll hire outside counsel like they did in our case. So they'll bring in litigating attorneys. Even if you don't have an attorney, they will bring in attorneys who all they do is litigate. And they use every system that's legal, but every trigger that they can, that they can use to benefit them. Well, I mean, they can do discovery, they can make you spend money on depositions, they can make you produce records, they can make you spend time and money, which is legal, but very hard on the wallet and very hard on your time, which are both very limited resources for parents, time and money, right?
And talk about the network stuff, the network of attorneys that the districts have, as opposed to the isolation that we work in.
Well, like I said, it's a really classic David and Goliath kind of situation, and I don't use that analogy lightly, but they are well staffed, they are well funded, and they're experienced. That's all they do every day. That's their job. And on top of that, they then are very organized. And I think this is true throughout the country, but it's for sure true throughout the state of Florida, is all the school board attorneys and the outside counsels that the school board utilizes to help them litigate against students are organized. They talk to each other, they go to trainings together, they train the judges who are deciding our cases, they train all the parent to parent groups that are supposed to help parents and represent parents. They're actually trained by these lawyers. They train school staff. And so you get all of these people saying the same things in the same way. And what I've seen over the years in the state of Florida is they go to a training every end of summer. So every July or August, they have one issue that they decide every year that they're gonna test out across the state. So you'll see something happen in Sarasota, that it also happens a few months later in Miami. It'll then happen up in Tallahassee. And they're making the same argument in the same way. So it's a very targeted and strategic and organized defense that they have against students. Now, it has nothing to do with any individual student. And I think that's one of the hardest things for parents to realize. It's not about your individual kid. It's not. It should be. It is to you. It's your child. It's your kid. What do you mean it's not about my kid? But on a system-wide level, it has nothing to do with your individual kid. And they're making strategy decisions and litigation decisions and efforts that really have nothing to do with your individual kid or how it impacts your individual kid. And so
I don't know, Miss Langer. I was just in several meetings this week where they kept telling me we needed to stay focused on the child.
Right. And yes, there's a lot of, we know this. If you've been involved in the school system, you know there's a lot of what I call double speak. So one side of the face doesn't know what the other side of the face is saying, and they may be saying that to you, but the attorneys and the system are saying something completely different behind your back. And so sometimes an issue will impact your child individually, but there's a whole system going on behind the scenes that really has nothing to do with your child, but you get caught up in the system. And so that's what, in my opinion, after a year of reflection, happened to this kid, DJ. There was a whole bunch of stuff happening behind the scenes that had nothing to do with this individual child, but he was caught up in the whole system of it. So when he was in third grade, there was the FCAT, which was the precursor to the FSA we have now. Standardized testing became fashionable. Kids were, bonuses and funding for schools, and adults' lives were impacted by the results of testing. So there was a statewide push to move kids off of standardized testing when they could, so they wouldn't lower school grades and teacher.
Did she just say adults' lives or adults lied? I think she said adults lied. What did she say?
Adults do lie. I said lives, L-I-V-E.
Lives.
Their career.
I couldn't hear her.
Their funding stream, right? So whole generation of kids who were improperly moved off of standardized testing on what we call in Florida access points or modified curriculum. So DJ was one of those kids. He never should have been put into a modified curriculum or moved to access points. But the reason they did that is so he became invisible, and his grades and his test score didn't count anymore towards any of these funding streams. And so everyone got caught. Eventually this caught up to the school districts. We believe across the entire state. We believe there was an audit done by the state of Florida or by some.
Let's not go into.
But we think a lot of kids were impacted, and DJ was just one of thousands and thousands of kids was impacted in this way.
But we proved it. We have 109 pages that the judge agrees. It was a year ago, and let's talk about what has happened since that year, right? So immediately we got the superintendent in Sarasota that said, we are going to work to find those other kids. We're going to make this right. We're going to find those other kids. In the newspaper, he said that. And there's been no indication that they've done any kind of work to find any of the other kids. I don't think they're looking. I don't think they want to. That is the first narrative, like public.
Well, I think one of two things have happened. One, the kids have graduated and they're gone. So they're not complaining anymore. They're gone. They either dropped
or they've exited, and the graduation may not have been how they left, but they're
Right,
no
so they
longer
left-
in the system.
Right, they got old enough, they aged out, they stopped going to school. Like DJ probably could have been one of those kids. So
Mhm.
the school system, or they were pushed through and graduated. I think the other thing that likely happened to a lot of kids too is they were made invisible again. So they were visible for a while, and then the school then had enough collected data, because it's data driven. They collected enough data to justify making the kid back onto a modified curriculum or putting the kid back on access points. So once again, they're back on access points. They aren't counted any longer in the same way. They become invisible again. And we know, I think I'm pretty confident to say that probably happened to a lot of kids who didn't drop out, because they tried that repeatedly and continually with this kid. They have tried to make him invisible again for the last year. You and I, we just have not let, and his mom, to her credit, have refused to allow the school district to make him invisible again.
And his big brother. He's had a very strong team. But the other point about that is, in the very beginning when this happened, we were just trying to help this one kid. We looked at this egregious situation. We just thought, what happened? Surely someone made a mistake. We've always been collaborative. And instead, we've turned into this evil laden witches baggage stuff in Sarasota. It's crazy. And they wanted to tell the story that we were like on a mission to find
to make money.
all these other kids, and we were on a mission to do this, and they had this crazy narrative, and they were telling people these things, none of which was true. I mean, the law says you have 2 years from when you knew or should have known, and by the time we even figured out what happened, most of these kids would have surpassed that deadline. So it's just some of it. Yeah.
And besides that, it took us forever, even in this case, to figure out all of what had happened to this kid. I mean, we, at the beginning of this, we just looked at the file and said, something doesn't make sense. How we got from A to B makes no sense. How do you have a kid with 100 IQ on access points? That makes no sense. How do you check those boxes? And anybody that doesn't know what I mean, if an IEP team in Florida is going to determine that a child has a cognitive disability, there's a form that they use that has a series of questions that the IEP team has to agree that the child meets all of those criteria. It's not like one or two. There's 3 questions. You have to check all 3 boxes in order for a child to be moved out of gen ed onto a modified curriculum. And one of them is that they don't have an average IQ. And so when we had this student that we started looking at his file, and we were like, okay, they did evaluations. Their psychologist said he has an IQ of 100.
Baby in the district school.
Yeah, best indicator of visibility. And suddenly, the week before FCAT, he's got an intellectual disability, although they didn't even say that. They left him as having a specific learning disability. They just checked the boxes. And
Without a psychologist present.
Yeah, and just moved him onto access points. Voila, no FCAT worries here. And so, now you need to know that happened in 3rd grade. We got involved when this kid was in 10th grade. So there were lots of years worth of things that happened between the initial event and when we, as an advocacy team, became involved with the student. And we had to go back and try to backtrack and figure out who did what when, and what documentation existed, and what documentation existed that wasn't being provided, because that was part of the game, to get to the point where we finally got a ruling. I mean, we could go through hours worth of what we had to do to get there. But since then, as we say, we who live here in Sarasota have not seen any evidence of anybody trying to figure out what the other 100 plus kids in our county that were impacted, or trying to provide some sort of relief or remedy for those students.
And I'm sorry, somebody is commenting about something, and I just want to break in and So there's somebody in here talking about what happened with the DOE audits in 15, 16, and the school system knew about DJ, and don't lay this on the superintendent because Mrs. Rose was the director of middle school. And I just, I keep hearing this because this isn't political. First of all, I'm going to tell you something. To the person that's posting this, we have been through thousands, and I'm not being exaggerative, I'm not exaggerating here, thousands of documents, and not on a single document was Karen Rose's name, not on one document. And never was she brought in as a witness, and never was she brought into this case at all. So I think the whole Karen Rose side of this story is just more shenanigans of politicians wanting to point fingers different ways. There was no, there was
Yeah, but the buck stops. So it's like with anything, the buck stops with the superintendent because they're in charge. And what the truth is that every year the school district has a continuing obligation to provide a free and appropriate public education to all students. And so no matter whether whoever the superintendent was in third grade was responsible, so was the one in fourth, fifth, sixth, seventh, and even today. So there were a lot of players in this case. I've never heard that name, and I don't know what you're talking about.
But somebody posted like 4 or 5 times talking about this lady, and she's a new school board member coming up. The other thing I would like to say is, speaking of school board members, we have had 3 very long-standing school board members on our school board. They were school board members before this time, during this time. They sit there today, and they've made statements in the paper that they don't even want to read the transcripts. They believe staff. They trust staff. Let me tell you, they should talk to us about some of their staff and their behavior under oath. And what occurred. I mean, that is partially, those people are still working with students. Those people are still being entrusted with big decisions in this district. And if these school board members want to believe those staff members, it's to their own. I don't even know how to express my frustration with, we don't have independent thinkers running our school district. We have cheerleaders that want to support staff, and it doesn't matter what staff says or does. Let's forget a 109-page order. Let's forget a second win that we've won. And let's forget that they're appealing us in federal court right now with a very aggressive time frame. And let's see what happens at the end of the day. Are you going to believe your staff until you fall on your sword? Or are you going to say you've got a problem and fix it? So,
and that's what I want to bring it back to, is we have never been involved with this student or any student for political reasons. It's always back to, how do we serve the children? What is the role of the public school? What is the role of the community and the advocacy staff and the parents and the instructors? And we have some phenomenal teachers and staff in our public schools. They are working in a system that is broken. They are working often with not enough resources, even though they have much more than parents do. They don't always have the resources that they need. They don't get always the professional development that we'd like to see them have. And so, when people try to make this egregious event that happened to an individual child in our county into something the adults get to bop a ball back and forth at each other politically, and blame people who are just trying to solve problems for children, it enrages me, because it detracts from the real conversations that we should be having as a community about how do we make sure that all of our kids are learning.
Yep.
For me, that's for me the biggest point. I am not from Sarasota. I'm the outsider that came in and started trouble, which is fine. I don't mind having that reputation or that label put on me. I wear it as a badge of honor. So I don't take any of the criticism personally. I'm fine with that. But what this for me really is I am a true believer in public school. I believe education is the great equalizer that exists in our society. I am opposed to vouchers, which is a whole different conversation for many reasons. But I came into this case because it was not okay with me that your taxpayer dollars are going to graduate a kid who's reading on a 4th grade level. That should not be okay with anyone who's in education. why are school board members or parents or taxpayers okay with us graduating kids who are reading at 4th grade school level? The whole job of the public school system or any school system is to educate children. So we should not be graduating kids who aren't reading at or near grade level. And so that's what happened to this kid. There was no reason, and we proved this. So the 109-page order is public record. You can go read it. They didn't educate this kid. They pushed him from year to year with no true education. And it wasn't because he has a disability, and it wasn't because he couldn't learn. He absolutely can learn and is learning, but not because the public school system educated him. So you guys should be outraged. I'm outraged that this has become a political case, that this is about the grownups in the room. This needs to be about this kid and all the other kids. Why are you graduating kids who don't read? And he's not the only one that I know about in Sarasota. There's a lot of kids in your county that do not read, yet they get a standard diploma.
Well, because it becomes about credits and not competency.
Yep.
And so we have kids who have no skills, but yet they get pushed through classes and they earn credits and they get diplomas, and we put them into the community without the knowledge that they need to be successful in education and employment as citizens in our community. And it has to stop. And
It really does make every community unsafe. And I'm not saying the kids are bad, so please don't misconstrue my words, but there's so much research that says when you aren't reading at or where you should be, you can't get the same type of job. You are more likely to be a victim of violent crime. You are not building on a safer community. It makes everyone unsafe when we have kids who are being pushed through the system like this kid was.
So it's going to make the two of you laugh that I'm going to bring us back, because
that did make me
we
laugh.
need to talk about what's happened in this past year. So the first thing that happened was, we went to another IEP meeting in good faith, thinking, okay, we're going to get services for him and it's going to be great. And we didn't prepare. We just walked in thinking, we're going to be friendly and we are going to focus on his education. And that's not at all how the district behaved. And let's not get into that whole story, but it was a very bad IEP meeting. It was the worst meeting I've ever been in. It was full of shenanigans, and they told us in the meeting they were gonna appeal the due process, even though they had not had a school board meeting to say they were gonna appeal. So clearly staff members drive the bus, before school board members get to vote on anything. It was just all very eye-opening and alarming. So we had that, and then we thought, we can't let this stand. This is a bunch of malarkey. So we filed another due process, because that's all you can do when you disagree with an IEP. So that happened like in December. And the next thing you know, Richard Corcoran, who is our Chancellor of Education,
Commissioner,
he sent a letter and he said he was going to do a state investigation to get down to the bottom of what happened to this kid in Sarasota. And it was big news. It was going to be a state investigation. And, but again, nothing's happened. They haven't called us. They haven't spoken to us.
Not just us. They haven't spoken to the mother. They haven't spoken to the student.
Mm-hmm.
So what investigation means if you're not talking to the people who are actually the victim of the incident.
Right. So it's like the fox in the hen house or the chicken in the hen house? Because the state doesn't want to say the district did something wrong, because then ultimately the state did something wrong because they didn't figure it out before the district really did something wrong. So it's that circular argument of, we can't say there's a problem because we didn't correct it. So if there's not a problem, nobody's in trouble. I mean, I think they're just stalling.
So yeah, I was going to say, Sue, I think that's more nefarious than that. And I hate to say that, but I think that they know there's a problem. And so these are efforts made to shut us down and shut us up.
You
And
think?
they've been successful. It's been a year and there's been no other kids identified and no other school districts reprimanded that we are aware of. Even though we know that.
So, I mean, districts are still doing it, Steph. We still get calls from parents throughout the state. They're still putting kids in IMD classrooms without an IQ score. I mean, nobody's learned anything. Nobody's fixing anything. And parents still don't know. So they're repeating the same problem, and it's continuing and perpetuating, all, in my opinion, so we can get that A grade. Because if we get that A grade, it's funding. And I don't know how many times I heard it, even yesterday's school board meeting, our new superintendent came from the best district in the state. Well, that's laughable. I mean, how can it be the best district in the state if you've got all these disparate groups that aren't reading and doing math? The numbers are abysmal. So we're not identifying and fixing still.
Yeah, and this is my call to action to everyone, to take back our public schools, because we have money. We're just prioritizing where we spend it in ways that I think are not where they should be spent. Was that
right? Right.
So what happened after DJ? What happens now? So it's been a year. He is enrolled in a private school. It took from, I don't know, July to October, which is insane to me, but here we are. We did have to file a second due process case. We won again. We were awarded more damages, including another year of compensatory education, another set of attorney's fees, and another meeting, which is, we had to draft a new IEP, which we did. The school district still refused to identify him as a public school student. So we actually filed a state complaint on that issue before the state ruled that they didn't have jurisdiction to rule, which I find baffling. The school district capitulated and agreed that he was actually a public school student. And then they agreed to fund a private school placement for this school year. They have not agreed to fund anything past the school year, and they're fighting in the appeals court to limit the number of years he can stay in high school, even though legally he can stay until he's 22. We do have the appeal going. They are seeking to overturn the order. But until the order is overturned, it remains in full force and effect. It can be utilized by parents in their cases. I think one of the most important issues that was raised in the order that other parents can use is the fact that this happened in 3rd grade. Lawsuit wasn't filed in 10th grade. There's a lot of years in between. There were a lot of consent forms and paperwork that the mother signed. So every year, every meeting, they're going to ask you to sign things. You're going to consent to things. You're going to waive your right to things. And what this order addressed was that issue in, I think, a very thoughtful and meaningful way that I think parents can use moving forward. So you sign stuff all the time because you have to. So it's not a judgment. You have no choice, but you have to sign things. But it's very important. And I think this mother in particular learned you can't just sign things without understanding what you're signing. So it's sort of a cautionary tale, this case. But I think the judge handled it really well because this mom really had no idea what she was signing. There was no informed consent. And I know we usually use that term in medical setting, that you're informed about a procedure and the risks, so then you knowingly sign something. We don't do the same kind of analysis in the education realm, but maybe we should. Are you informed about the rights and the responsibilities and the risk?
Well, and I think more than just that she wasn't informed, the information she was given was false.
Yep.
Mm-hmm.
So it's impossible to give informed consent if the information you're being provided by the professionals, hence they recommended a modified curriculum for a kid who doesn't really have an intellectual disability. All the information she was provided was not accurate.
Yes.
And so she was making this. So even if she understood the forms, she was making decisions based on information that was inaccurate. And so
it didn't matter whether it was intentionally. We didn't have to prove she was intentionally lied to or they intentionally hit the ball. No. So that was nice. Like, we didn't have an extra hurdle put in place. It wasn't accurate, and she wasn't held responsible for signing those documents. So I thought that was an important thing we can use moving forward in other cases.
But it is really, you know what, when you get that stack of documents, you're not buying a house. You don't just sign every piece of paper that's put in front of you without reading it. If you don't understand, like, you know, they say when you sign, unless it's your initial IEP, if you sign an IEP, you're just stating you were present for the meeting. You're not consenting to the IEP. But there are pieces of paper you're asked to sign where you are given consent. If that is one of those things, you need to genuinely understand the impact on your child before you put your signature on that form.
Right, and it's important to know that these computer systems generate the forms, and there's lots of language that gets embedded to an IEP or a 504 plan that they don't review with you in the meeting. And so even when they issue you drafts, that language isn't printed generally. And so you won't get the final language printed until you get the final closed copy. So then they say things to you like, oh, well, you can't read it in the meeting. Don't be afraid to push back on those kind of statements. If you don't understand something, put it in writing that you don't understand it. Because what the kind of language they have embedded in modified curriculum, IEPs, and other types of paperwork surrounding modified curriculum or access points is you understand that your kid may not graduate with the same knowledge as other students. There's some very creative language that unless you're really paying attention, you're really cued into what that means. It is very possible the judge could have gone the other way because the language was there, but it was scattered. It was spread across many documents that she signed over the years. And it wasn't really clear unless you knew what they were saying. And unless someone really explained it to this mom, she really did not understand what it meant.
We're getting so into the nuances of yeah. I think what we'd like your takeaway to be is if you're sitting in a meeting and if somebody tells you something that you don't understand, it's not clear, it doesn't seem right. If it's not in the document, if they won't put it in writing, your first job is to go home and send an email to those people and say, here's what I heard you say. Is this what I understand? Please explain this to me. You get one shot at your child's education. There's no
stupid question.
Yes.
There's no stupid question. And I'm telling you, you're going to ask a question and they're going to be like, I have no idea what that stands for. I don't know what that means. So they're telling you things that they don't even understand the whole nuance about it. So don't be afraid. If you say, I don't understand what that means, they probably don't either. They meaning the people who are telling you to sign the form, because it's just standard language. It's embedded into everything. No one really knows what it means. So unless you take the time to really look at the nuance and how it's implemented, so don't be afraid. Don't be afraid. You are not alone in saying, what does that mean and how does that impact me, my kid?
Right. Well, so the deference is given to the district because they're supposed to be the experts. The district and the school are supposed to be the experts. So you have to use that. You have to go to them with your questions. You have to get them to clarify what you don't understand. And if they've said something, as often has happened to all of us through the years, they say something when you actually, send the email and say, this is what they say, they backpedal or they tell you it was a misunderstanding or, those things happen all the time. So it's very important to clarify.
That's our policy.
Yeah.
Okay, well, can I read the policy? Sometimes there is no policy. It's just a practice.
Yeah.
And if it's just a practice,
so getting back to
that's not enforceable. So anyway, we're in DJ.
So getting back to this year, so there was the state investigation is still just, nothing.
We don't know.
It's, I did a records request to try to get some records and who knows? I'm sure they've got bigger fish to fry and this is not going to be an investigation until the federal complaint is done and then something will happen. I'm guessing, if at all,
Yeah.
But more concerning in our area, no policy and procedures have changed.
I would take issue with that, Sue. I think policies and procedures have changed because
you're right.
What has happened in Sarasota, which is that they're shutting down particularly advocates, but also attorneys from representing families.
Yep.
And that's a very, very disturbing trend that I wish people would push back more than just us on, because parents have an absolute right to be represented by counsel, but also advocates in the state of Florida. And Sarasota has gone very far to shut down any parent having help through these very complicated processes.
Yeah, I would agray with you.
I think that's been the most tragic backlash.
If you're working with an advocate or an attorney that is being welcomed and communicated with, and they keep you on all the emails, like we're finding a lot of these There's actually been an instruction in Sarasota County. If we're on the email thread, take us off. So oftentimes we aren't getting the information at the same time the parents are getting, even though they've signed all the consents, they've got all the forms, we're sitting in meetings with them. So if you're using one of those attorneys locally, and I won't mention any names, that is very cozy with our school district, and that, you know, the opposing attorney doesn't come to the meeting and everybody welcomes them, be concerned. Parents, be concerned.
So let's get back on to finishing up DJ, because we need to get to the other thing we told folks we would talk about tonight.
But despite all the crazy on DJ and this very exhausting year since our win, I do think it's so important to acknowledge that we won. It's such a rare occasion in the state of Florida. It's so rare for a student to win that I celebrate Sue and Susan with my line and say congratulations to you two, because we never would have gotten here without you. And I think we celebrate the wins because there are so far and few between. And it really was amazing, and it was the right thing to happen. And it's so nice when that all comes together. So thank you, ladies, and congratulations again.
Well, and thank you for guiding us through the process, Steph, because one thing what I'd like parents to walk away with is due process is one of the few tools we have for grievance. But if you decide to go down this road, you absolutely need legal representation. Like we've been advocating for, decades now. We started when we were in kindergarten, and as advocates, but I'm sorry. And you objecting to me? And but we knew when we got to the place that where we were going to have to file due process, we had in good faith tried every tool trick we knew to work with them and to get to a place where we could come to an agreement on how to fix the problem that had happened for this child. We did not take it upon ourselves to file due process because it's a legal process. I mean, if you don't have a law school background or you haven't been a practicing attorney that's been through litigation, you don't understand all the process. Even if you understand the laws, like there's a lot of parents who spend hours and hours and hours reading laws and going to training with attorneys, but if you've never been in a courtroom, if you've never filed motions and responded to discovery requests and don't know what a Bates stamp is, you're not prepared to go through due process alone.
Well, and then think, even if you win, like we did, even if you do and you win, when they decide to appeal it, could you go to federal court alone? I mean, it's a lot of legal.
Right. So
they treat it like a legal case. So they don't treat it like what it's supposed to be, which is an informal process that a parent can do without counsel. That's not how the school districts approach it, even though that's what it was intended by statute. And until that changes, though, school districts are going to continue to view it as litigation. They do not play fair. I'm not saying they lie, although that happens sometimes, but even if they play within the legal rules, it's still not going to feel fair. And it's definitely not, they don't level the playing field. That's their job, is to represent their client, which is not your kid, right? Because remember, it's not really about your kid always. So I appreciate you guys saying that. Florida, you can go to due process by yourself. And in Florida, you can actually have advocates go to due process for you. It's not illegal in the state of Florida, but it's litigation. It's a legal process, and it's, you're usually spending money. So spend your money in the way that gives you the biggest bang for your buck, because the school board is not going to be nice to you because you don't have a lawyer or because you have an advocate and not an attorney. They're not going to change their tactics. If anything, they take advantage of your lack of knowledge or lack of experience. And if you're a lawyer who happens to have a kid who you think, oh, I'm a lawyer, I can do this. Again, it's your kid, it's emotional. It's like don't operate on yourself if you're a doctor. It's kind of the same theory for law. Don't litigate your own case. And if you happen to win, you won't recover your fees because you're the parent, not the lawyer. So, and that's my only sense on that.
So our bottom line is we're so glad you took our phone call on a Friday and met us and took this case, even though you were tired and exhausted when we got to you. Because,
burnt out.
Without our team and the expertise that you brought to it, we wouldn't have this win for this young man. And we are just really hopeful that the true end result of this will be that he gets everything he needs in order to go forward and live a successful life. And in case anybody wondered, I mean, we really try to keep the personal about the child out of this, but he's the great kid that just he has ambition. He is still trying to learn. He is trying to take advantage of every opportunity he's being given, even though he now knows the story of what happened to him. And that's been very hard to process, because what kid wants to hear that your school didn't treat you well? But he is really trying to make the best of a bad situation and take advantage of the opportunities. And so, as much as it's been a long road to get to where we are, we just have the greatest hope that this young man's life will be better because of the work that was put into it. And, bravo to him.
And his mother's a rock star. His big brother's a rock star. I mean, there's been a huge support system around him, and all very grateful and thankful that this was figured out, and it's made a difference, because his life would not have looked the same had he not been given the opportunities he currently and recently has been afforded, as we continue to fight the shenanigans of Sarasota. So can I just mention one more thing before we go off into our other topic? I would like to mention that the two attorneys that fought against us, one of the, big shot legal beagles, who trains districts and judges and people, he went off and he took a job somewhere in a different district in Sarasota. And our local attorney firm also left the case, and they gave us to another attorney who we didn't know before this, who practiced out of Orlando. So although they fought us on 2 due processes and lost twice, and they decided to go to federal court, they just handed the case off to someone else. So I just think that's a point that's important for people to note.
Yeah, back to the deep end.
Again, they litigate it like it's, they litigate it. And when it's not going their way, they'll bring in the next big attorney to come.
Well, or, do they really want to lose 3 times? Do they want to make the decision to go to federal court, and then they don't want their name on a losing federal appeal, right? They're going to get somebody else.
Well, we don't know their motivation, but the point for parents is to understand that the bench is deeper than you ever imagined.
And the funding is unlimited.
Right. If they would have just paid this kid what he needed to get him where he needed to be, all of this could have been avoided. And if we had elected members of our school,
except Sue, if we had not litigated this case, I personally would never have understood the depth of what has happened to this kid and a lot of kids across the state. So they hit it well for a long time. And I almost feel like it was serendipitous, and it was hard work, and it was a lot of luck and tenacity and, never giving up, that we were able to uncover what occurred. I think that the cover up of what occurred, and I know that sounds kind of conspiracy theorist, and I'm not a big conspiracy theorist person, but I think the depth of the cover up was immense. And I think if we hadn't litigated this case the way we did, and I think they could have gotten rid of us years ago, and they didn't for whatever reason.
Yeah.
Able to really uncover what happened to this kid and what has happened to thousands of kids across the state of Florida.
And let's thank, while we have a minute, let's thank those school district employees that actually did stand up for kids and actually did try to do the right thing, although they got squashed and,
Retaliation
horrible things have happened.
Yes,
Mhm.
retaliation is real to families, it's real to employees. And I have said this for decades. Until the teachers stand up and talk and fight for kids, nothing's really going to change, because parents and their councils and their advocates are always on the outside. And we're not, until we get an insider, a large group of insiders to stand up for kids, really, it's going to be hard to change the system.
And, I think the last point before we leave this is we also want deliberate indifference. And I think that that's a really important point. So Steph, for those parents who don't know what deliberate indifference means, can you explain it?
Yes.
Maybe a little bit about the associated laws that go along with IDEA.
Right. So we talk a lot about the IDEA or IDEA, which is where most of your rights and your responsibilities lie for kids with special ed. They only exist in the public school system. We know that. So when you leave the public school system, you're giving up a lot under the IDEA. But other laws that exist are the ADA, Americans with Disabilities Act. But there's also a law called Section 504 of the Rehabilitation Act. It predates all these other laws. And really Section 504 of the Rehabilitation Act is it's an access law, meaning you should have equal access to not only the building, but the curriculum and the education that other students get. So you'll see it a lot in, like, a kid needs a ramp, things like that, but it also exists in our case. And so what we were able to prove, which I do agree with Susan, is very useful for future cases, is the fact that because this went on for so long, and because so many people knew about it, and because so many people turned a blind eye and didn't step in to fix it, the court actually ruled that we established what's called deliberate indifference. And deliberate indifference is a standard, it's a legal standard, where someone who had the power to change it didn't, and let the discrimination or the problem continue. And so in this case, they found that school district and their employees who were in power spent years ignoring the problem and ignoring what was going on with this kid, to the point where it became actionable and we were able to establish and win a Section 504 claim under the Rehab Act.
Didn't you say it was systemic? A systemic problem? And we still have that systemic problem, Mr. What's his name? Asplin, Dr. Asplin. We still have it. So I heard in yesterday's board meeting, he was going to put together a panel of people with disabilities.
He's our new superintendent in Sarasota, for anybody that's
sorry,
watching.
I had no idea.
That has no idea who Sue's talking about.
He's going to put together a panel of people to try to solve our achievement gap problem. Yeah.
Good. I hope he does. That's what the public school system is supposed to do.
Agreed.
It's important for parents to know IDA is not your only place that you have rights. And so don't be afraid to pursue all of the avenues. A lot of parents will file pro se, by themselves, or an advocate will file by themselves an IDEA case, but they won't file a 504 case. And sometimes I think that's a missed opportunity. But in the state of Florida where we live, you have to file administratively first before you can go to, like a federal court or state court. And so if you don't file it within your due process case, you may be waiving your claim, and you never want to waive something that might have money damages attached to it.
Yeah. So we have about 5 or 6 minutes before we're going to be done here this evening. So we hope that everybody, appreciates the year worth of trying to actually get things in place once the due process was won, or actually 2 due processes were won. And so, I guess I want the walkaway to be that even if you file and even if you win, it doesn't mean automatically everything's solved the next day. There's a whole process.
It's just the beginning.
It's the beginning, not the end.
Correct.
And so then it becomes the whole negotiation of how to actually get what you won, and what does it look like, and who's going to deliver it, and where's it going to be delivered. And
I think, how do you navigate? So we won, so that's it's a bubble, but every day the district still has a continuing obligation to provide FAPE, a free appropriate public education, right? So how do you navigate having this win where people's feelings might be hurt and they don't know how to implement it, with your kids still having to go back to school and still being entitled to free appropriate public education? And again, a win is just, to me, step one, that's the beginning. then you've got to figure out how to navigate all this stuff moving forward. And it's not always a straight line. And it hasn't been a straight line in this case by any means.
No, I mean, this is just like a goalpost that we needed to like, remember we won.
Yay!
And then, you know that we still have quite a battle in front of us for this kid to get what I believe he deserves because of what he lost. We'll never fill out, we'll never make it up.
And it's been almost a full year before we got him in the private school.
Yep.
Like a full year. And he just started last week. So, yeah.
Yeah. Okay. So the other thing that happened, I actually don't have the date of it, but I just got my hands
It
on it.
happened on the 16th.
16th. Thank you. This week is, and those of you who maybe are joining us that aren't in Florida, this is a Florida specific new accommodation. And that is specific to the Florida Standards Assessment. And so
For reading and writing only.
Right. So auditory presentation for English language arts, reading and writing passages for students with severe decoding deficits.
So explain, Susan, explain that.
So we can put, if I can technically figure out how to put it on the Facebook page, there's a link to this memo. So just so anybody that, I don't know, doesn't follow policies in Florida very closely, there's a place on the Florida Department of Education website that you can sign up to get their weekly memos of new policies that they issue. And you may learn way more stuff about things that you don't care about, but every once in a while, there's a diamond in the rough that really impacts, kids that you care about and you want to know about the latest policy. And just from an advocacy standpoint, over the years, Sue and I have found it to be very helpful when you're trying to solve a problem in your district that maybe it's been a statewide problem, and then they issue one of these memos. And if you know about it, you can then say, well, according to the memo issued on X date, it says we can do whatever. And they go, oh, yeah. Mm-hmm.
In this case, this memo was October 16th, 2020. For those of you saying it's not new, I think that's pretty new.
Yeah. And I know I belong to a lot of dyslexia groups, and they were all pretty excited that this was something potentially another tool to avoid what is perceived as punitive consequences sometimes for kids who are non-readers. And maybe they're non-readers because they haven't been getting the appropriate instruction that they need to learn to read. And then they hit third grade and it's a do or die, pass or fail moment. And if your child doesn't meet standards or can't demonstrate that they meet standards in reading, it's a mandatory retention.
And it's mandatory enrollment in these remediation classes, these intensive learning classes.
Right. Now there's a waiver process now where parents can opt out of that part of it. But if your child doesn't meet a good cause exemption for retention, there is like very little that you can do to get around that. I mean, we're not going to talk about that in depth tonight. Go ahead, Steph.
No, I just wanted to say, so we have standardized testing. Standardized testing is supposed to measure what a student knows and their knowledge. So sometimes kids' disabilities interfere with us getting an accurate picture of what they know. And so this community, the dyslexia and dysgraphia community, have been fighting for a long time that standardized testing doesn't actually measure what this student knows because they can't get the information out of the kid through the standardized testing. So I think what this accommodation did, which it did exist in math. So if a math question was being presented, the math question could be read to the student, but it never existed for reading or writing. And so, because in reading and writing testing, we're testing, can they read and comprehend what they're reading, right? But because of these disabilities, that interfered with us getting a true picture of what this kid knew or their knowledge base. So
and I was gonna say, this scares me a little bit because there's always unintended consequences for anything we do. And I am very worried that if we are giving a way out that kids don't actually have to learn to read, like, we're gonna maybe have less, less readers. So that's my big, when I saw it, my initial response was not to dance in the streets. Mine was like, oh God, here they go, finding another way to not teach kids to read. But I think it's important, there's a few parts of this that I just want to throw out there for parents to understand that, one, that this is a unique accommodation. And so it's got to be applied for. It's not just, so if the IEP team agrees that this is appropriate for your child, the Commissioner of Education has to sign off on it.
Right,
So
it's not gonna just be in your,
Yeah.
right, it won't just be written in your IP and suddenly you get it. There's gonna be several layers before you get it.
Right, and it's got to happen at least 60 days before the first day of testing. So it's got to be, it can't be like in our DJ case, the week before FCAT, suddenly he, had a huge change. For this accommodation, it's got to be something that's happening in the classroom and that it's thoughtful. The student must have a documented deficit in decoding, and there's actually a chart in the memo, in the attachment, that tells you what that means according to the state. The student must be receiving evidence-based intervention in addition to core instruction at the time the accommodation decision is made. And they send you to your district's comprehensive evidence-based reading plan to figure out what that means. But what I thought was, I was like, what is the definition of evidence-based? And so my University of Connecticut, I came up with a document that an evidence-based intervention is one that has been shown in controlled research studies to be efficacious. Oh gosh, it's a word I can't say, one of these college words, efficacious in improving student outcomes.
Right, it has to have efficacy, which means they can repeat it. Right.
But I can say efficacy. I can't get it with the sh on the end.
Me neither.
For this
That's why I changed it.
For this reason, evidence-based interventions are also commonly referred to as research-based
You
interventions.
could probably read it to her.
Huh?
No, but I think that's important. So you've got to have those programs in place for your student. And it's very hard to get those programs from a public school system. So parents are often fighting to get those programs put into place. And in order to get the accommodation, you're going to have to show that your kid had that accommodation, had that program for a while. So
Right.
It's an interesting.
The bar for this is high.
Correct. It's an interesting hoop that parents are going to have to jump through. That's not easy to get.
And so the next one is, we've got more, so don't get excited. The student must receive accommodations in Tier 1 and Tier 2 daily instruction to access printed text in classroom assignments and tests. And so then they list like learning allies. So this is assistive technology. That's what you, there must be data to support the student's effective use of a reader, audio recordings, or text to speech through a reading accommodation assessment, such as, but not limited to, the Universal Protocol for Accommodations in Reading, known as the UPAR.
My problem with this, Susan, is it looks okay on paper, but the practical application of this is going to be a nightmare for parents.
3 more bullets.
Oh God. Okay, keep
Must
going.
show proficient scores in daily instruction to include formative and summative assessments when the accommodation is used. The result of a student having a reduced ELA scores and/or low listening comprehension or receptive language score would not be criteria to receive the accommodation.
Well, that's good. You don't have to fail first before you get the accommodation. That one.
The IEP team must complete a unique accommodation request form for this accommodation that's signed by the district DSE director and district assessment coordinator and submitted to the Commissioner of Education for approval.
Oh,
The process can take place at any time during the school year, but the request must be forwarded to the DOE no later than 60 days before the first day of the administration window of the statewide standardized assessment for which the request is made.
Wait,
So
what are
really,
you
it
reading?
has to be done in the first semester of every school year. So once you hit January, you're going to be too late.
And then a request for auditory presentation of ELA reading and writing passages must be submitted annually and approved by the Commissioner of Education.
Every year, you're going to have to renew it.
Yeah.
So to me, that is so crazy because we can't even get reading instruction in public school in Miami-Dade County because they no longer have reading classrooms and they no longer have reading specialists. So who's going to be doing this? Who's going to be implementing? We don't even get regular accommodations implemented, let alone these complicated ones.
Right. So I just wanted,
It's just,
I intentionally went through that huge, long list of hoops because I want parents who read this, maybe saw the memo, maybe saw it was posted in a lot of places on Facebook. So maybe you just saw the, hey, look at this cool new accommodation post. But parents to understand that there are a lot of hoops that you need to go through for your child to be considered for this accommodation.
and it's going to take probably take a couple school years to really have
Yes.
implementation that you're
Well,
going to need.
So would it even
And-
be possible to get it done
and
for the
wait.
school year?
No, this
We're already
school
out of
year, no.
time.
No,
Well,
this
it
school year.
depends. If your
If you
child
have
is,
a cooperating school district that
Well, and we might because they want their numbers to look good for the
Sure.
passing rate of grade 3.
Sure.
well, and
Sure.
it may be that your child is already involved in some of these interventions. Like you might already be in the process. The one thing that's really important, and it was in the memo, not in I was reading attachment A, but in the memo itself, this is only open to kids with IEPs. So if you have a child with a 504 plan,
Right.
you are not going to be even considered for this accommodation. And that's important because I know there are families who have kids with dyslexia and they may only have a 504. This is not open, available to that child. And it also specifically says this is not for just people who are below grade level readers. This is for non-readers. So
It's going to be very narrow.
Oh.
it is.
It's a
It
very
is.
narrow application, and parents are going to have to understand each hoop and be able to trigger all the hoops to be able to get eventually over a couple of years this accommodation.
Right. And because it's
Great
brand new,
one.
we don't know practically what the application of this new thing is going to be.
Right.
And I'm not sure exactly what group pushed for this accommodation. Like, I don't know where it came from. And so sometimes what we see is it depends the source of what triggered a new policy, how it is practically implemented.
Well, think about you guys, the waivers, back when they had waivers and like we had very, very significantly impacted students who couldn't get a waiver. So even though waivers were available, who was the commissioner of ed back then? Nobody could get that done. So I'm wondering, is this the same kind of thing? Like, look
Oh,
what we're
Pam
offering you.
Stewart. It
Yeah.
was Pam Stewart when we
Yes.
had the children with significant cognitive disabilities that the family was like the alternate assessment doesn't even is not relevant to us and monitoring progress. And but then you had they have family here in Sarasota actually had to take it to court in order to get one of the waivers. Yeah.
And because you helped someone, Susan, I remember back then, there was a mom in Sarasota that you helped figure out how to get the waiver. So I guess the bottom line is, Sue Sasko, put away your dancing shoes. You might have a little more work to do, huh? Is this what we believe?
No. I believe like Johnson, like
No.
our case in DJ, we celebrate the wins, and this will help some children who maybe have been fighting for this a long time.
True.
I think we celebrate every step further away from pigeonholing kids in circles that don't fit them. So no, we celebrate the win, but I think it's important for parents to know how complicated and not straightforward this
We are celebrating with you,
to
Ms.
be.
Langer. We are definitely
celebrate.
celebrating with you.
So Susanna, you celebrate, my friend. You celebrate.
Yeah. Yeah, no, so we were celebrating with you. It's
It's so
it's that
frustrating.
dichotomy of
Yes. The
how do,
reality versus the paper. Yes.
right, because you know what, I shouldn't speak for I know that there are different pathways that we need to make open for kids to be able to demonstrate their talents. And there are many, many people who are struggling readers throughout their life, but they have amazing gifts to offer to our world. And
Yes.
they have alternate ways that they take in information and deliver information back out to the world. And we don't value those differences because we have such a narrow way of measuring what's important in our public school system because of standardized testing.
Right. Let's maybe get rid of standardized testing. Maybe.
Except
mixed
again,
feelings about it. I have mixed feelings about it, but
Yeah.
maybe we should. Yeah.
right. And it's so how do we hold people accountable
Right.
for actually teaching our kids what they
Teaching
need to
children.
know without penalizing our children for not getting what they deserved?
Or not being a
But-
circle in a circle, or not fitting
Right.
on the conveyor belt that we've designed for the mass.
Right. Where, unfortunately, kids aren't widgets. It's hard to make specs that everybody
Every
can conform
kid.
to.
Mhm.
No, it's true. And so we just need to be very broad in our,
Or creative, or I don't know, like, where's our priorities? Do we rethink how we're teaching kids and what we're spending our time in the school day?
yep. So that's really what we had for you guys tonight. We're so thrilled to be back
To be
on
back.
live. Yay. And we hope everybody has had a successful return to school. COVID has made everybody's life different
Very
and
chaotic.
challenging. And at the end of last year, seems like weekly, we were on here talking about hybrid learning and at-home distance learning and mask now and returning to school and, are you remote or are you brick and mortar?
My kids are in my garage, so that has not changed for me.
Right. And so I'm sure we're going to come back and talk about some of those issues again. And some of the other things, I know we had talked about comp ed being a topic we want to touch. And honestly, some of these things are still unfolding. And so it's not that we have lost sight of these. For you guys out there, wondering, are they ever going to talk about that stuff they said they were going to talk about? It's not, it's just that we still are waiting for information to come forward before we dive into some of these hot topics. Steph's making faces like, oh.
Yeah. I'm about to file. I think we're gonna file on the comp ed issue. I think I have a test case we're gonna run through. So I'm happy to share it with Facebook when it's more solidified. But some of these things I think there are no good answers, and some of them are gonna have to be litigated, unfortunately, because the school districts in the state of Florida and I think other states as well have really not stepped up like I was hoping they would to address some of these issues. And so I think it's going to be on, unfortunately, the student's shoulder to step up and force the courts and or the school districts to act, unfortunately.
Well, and I'm always trying to look at all sides of an issue. And I think some of it is that our systems are so overloaded in trying to figure out how to live in this new world we're all navigating, that they don't have teachers, they don't, not that should be the student's problem, but it's turning into it.
Well, and I think all the cracks that parents of special ed kids and us as advocates have seen for the last 20 years, now everyone's singing. So it's been interesting for me, an interesting progression from being in the dark and me being like this dirty little secret that no one really knew about unless they were in my little bubble. Now the light has really been put on the cracks in the system. And for me though, instead of being sort of depressed and sad about it, I really think it's a time to do a call for action to take back our public school systems, because it's unacceptable for all kids. And now everyone believes me. You know, like people are like, that could never happen. And now they're like, oh, okay, now we get it. Yes, it does happen. So taking this knowledge that now the light is being shown, you know, I'm such a proponent of the public school system. Let's take it back, people.
Well, sometimes out of chaos comes solutions, and I think opportunities. And one thing that here's my final thing for parents tonight. We have indicators out there in SPED world that the law may be reauthorized in the next Congress. We're kind of hearing rumblings of that. And so I would say, parents, it is time to start paying attention to federal policy. If that isn't something that normally is, you know, your light bedtime reading. No, seriously. I mean, many of us were so caught up in our own little worlds and getting through the day that paying attention to what Congress is up to is the last thing we want to think about. But you know, all the rights that your children and benefits that they get from special education are because we have federal law that mandates people do that. And so we have seen, you know, when it changed from the law in 1997 to the law that was reauthorized in 2004, parents had some losses in that transition from 97 to 2004, especially when it came to behavior and the
funding, actually.
Yep, and funding, and the burden of proof being shifted in some things from the school district to parents. And so paying attention and being ready if somebody calls you to action to say, hey, send an email or call your congressman or show up in the Capitol with your kid in tow, if you're capable of that. The Army needs to start preparing and cleaning your weapons because the war is coming. And I don't mean to be melodramatic about that, but it really is going to be a battle.
Well, and I truly believe this is an opportunity where we're going to have voices, we're going to have ears bent listening that may not have before because they didn't really understand because it wasn't happening to them. How old and antiquated our system can really be and how our funding is kind of messed up. And so I think you're going to say, remember when your teacher didn't show up for class? And we're going to say, that's the same thing for this kid who needs a black pencil because he can't see the paper. You know, sort of nonsensical things that are happening every day in our world.
Well, it's true. And I think even though, you know, we don't have the state DOE people calling, wondering about what happened and how did this happen, there have been other legislators that have called us to say, I want to understand this because how can this be happening in Sarasota? And how can this be happening in our district when we give all this money and we have all these foundations and we have all these things? So to your point, Steph, people are waking up, and it might not be the people that's job it is, but it's other people that are, they'll have a voice in it at some point. So I'm thankful for that.
Well, and they'll have an understanding finally of all these things that seem so that could never happen and people wouldn't do that. Now that does happen. People will do that, and there are things that make no sense in our system.
Exactly.
Yeah. So,
all right. Well, hopefully we will come up with another date to join you guys live again, and we'll post it out in the IEP for Parents Facebook page, the IEP for Parents group. If you're a parent, we kind of reserve the group just for you guys. So if you're professionals, we are glad you're with us, and check out the page. But the group, we sort of try to keep just for moms and dads and guardians and grandparents who might be raising their kids. And then we also have the IEP for Parents website with some good resources, and we are having some revamping happening there. So if anybody has a little bit of technical glitch, try back the next day because our tech team is right on top of that.
And definitely let us know if there's topics you guys are wanting us to talk about, because you know we can talk about this for days and days if you let us.
So today we cheer to DJ and Team DJ.
To the successes, all of
Yep.
them, little successes, big successes, getting a meeting schedule you've been waiting for 6 months. Cheer all of these little and big wins because you deserve to be cheered for that.
And if you have questions, throw them out there and we will, you know, give you an answer or make one up or something like that.
Oh, we will give you an answer.
All right. Have a great evening.
Bye, guys.
Bye.
Thank you.